Hello, I'm Rick Johnson. It's been my honor for the last 15 years to serve as your Court of Appeals judge, and I'm pleased today to be moderator of this program where we will be discussing personal injury and negligence law. This program is part of Law Day celebration, and it's sponsored by the McCracken County Bar Association and the West Kentucky Paralegals. We're very pleased to have a distinguished panel with us today of three very experienced and able personal injury attorneys. I'd like to introduce them at this time. First, we have Kevin Shannon. Kevin is with the firm of Bryant and Counts. Kevin has practice that concentrates in personal injury and criminal defense. Len Ogden is in a solo practice. Len also has a practice that concentrates in personal injury and criminal defense. And Craig Housman is also a sole practitioner, and his practice concentrates in personal injury, workers' compensation, and Social Security disability. Gentlemen, I think it's been all of our experiences that probably the most frequent case that we see involving personal injury and negligence law would be the automobile accident. And Kevin, I'd like to start with you if I could. If you could tell our viewers just a little bit of background information as far as what they should know concerning their rights and responsibilities in relation to automobile accidents.
Well, probably the question that comes up most often is the issue of insurance once there's been an accident. And Kentucky law makes it mandatory for every owner of a motor vehicle to make sure that that automobile is insured to at least the minimum extent of $25,000 for bodily injury liability coverage per person, and up to $10,000 for property damage coverage per person. And most often that's the question that people have when they first call our office anyways is, hey, I've been in a wreck, I don't know what to do, I've never had anything like this happen to me before, can you tell me a little bit about what I might expect? So that's the way it usually arises.
Okay. Len, when the clients come into your office, what information should they have with them, and what would you expect them to be able to provide you so that you could give them a fair evaluation of whether or not they have a claim and whether or not they should go forward?
And I assume you're still talking about a motor vehicle accident?
Yes.
Well, I like them to come in with the accident report, but most often I will be the one that gets that, and usually when they call, I'll go ahead and try to pick it up ahead of time. Because I need to know what the officer observed and heard at the scene, and usually he arrives after the fact. Further, I like them to bring in any and all motor vehicle insurance policies that they may have, their own, of course, and if they're covered under someone else's. You know, sometimes we get that situation. And then I sit down with them and want to get the facts and from them, and that's for the most part all I ask for. Then we get into subsequently photographs if they have those, and those types of things. But that's mainly it at the beginning.
Okay. Craig, when you're talking with potential clients or clients about their injuries that they may have received from an automobile accident, are there any other considerations that might come into play there as far as any other potential liability?
There certainly are. One of the things that I see fairly often is folks, who are on the job and involved in a motor vehicle accident. And if that happens, then if they're doing what they're supposed to be doing for their employer at the time, then there's a possibility that they may be entitled to workers' compensation benefits, which raises one of the questions that I get asked most frequently on the front end. Was the person calls and says it was all the other fellow's fault, but his insurance company says they're not going to pay my medical bills. And one of the things that we've been dealing with in Kentucky for, I guess, close to 30 years now is our No-Fault Act, and yet it seems to be news to most people that so far as their initial medical bills and the wage loss, that's supposed to come from their own personal injury protection coverage on their own automobile. But back to the question you asked me, if for instance they were involved in their work duties at the time they were hurt, then you get into a situation where the workers' compensation is primary under one of the provisions of Kentucky's No Fault Act, the no fault insurance carrier insists that the workers' compensation carrier be responsible for everything that work comp would cover. And one of the good things about workers' compensation is that it does cover all medical expense. So, and there's still some circumstances in which the person can receive wage loss benefits both from the workers' compensation carrier and from his own no-fault carrier, depending on the circumstances of the accident and how great or small his work injury loss is in terms of lost wages.
Well, in an automobile insurance coverage situation, what type of activity would that include? Does the person actually have to be driving the automobile, or are there other activities it would cover?
That's one of the things that I run into more when people call me about accidents they've had at work, and it seems to be a recurring fact pattern where somebody's working either as repairing a truck at work, or he's loading a truck or unloading a truck, and if, for instance, the person falls off the back end of the semi when he's trying to climb up on it to raise the trailer door or whatever, but if he falls off the truck, if he's in the process of getting onto it or getting off of it, and it happens on the job, then no fault applies to that as well. If you're in the process of loading or unloading the truck, it's covered. There are some exceptions to that, where if you're standing on the ground, it doesn't apply. I know, like there's one case where a fellow was removing the boom on the chains that held a load of logs, and one of the logs rolled off and really seriously injured the fellow. But because he was on the ground in the process, that wasn't covered. So the bottom line is, if you get hurt and it involves a vehicle, no fault is something you need to look into in terms of whether or not it will cover it. It doesn't always.
Let me just add a couple of things to that, if I might, Craig. The no fault also will cover people who are riding as a passenger in a motor vehicle, a pedestrian that is hit by a motor vehicle, and what no fault really does is, and it was designed to do, was to pay medical expense and wage loss and other economic losses. For instance, if you have to hire somebody to work around the house while you're recovering from your injuries, to pay those types of things in a quick manner. The lawyers didn't like no fault when it was first passed, and I'm not sure I still do, but I suppose it's a good thing. One other thing I would want to point out to those that are listening is that if you're in a motor vehicle accident, you need to find a lawyer that does that type of work on a regular basis. And if you're injured in a motor vehicle accident when you're on the job, such as Craig was talking about, you need to have somebody that also is schooled and experienced in workers' compensation law. I don't do any workers' comp law. So recently I had a case and it involved an accident that occurred on the job, or at least we believed it did. And I'm handling the personal injury part, and I have to be humble enough, and that's hard to do sometimes, but to know that I don't need to handle the workers' comp. So I referred the workers' comp part to Craig. Now, a lot of law firms like yours, Kevin, I think handle both types of cases, do you not?
We have at times, and sometimes we don't. It depends upon the circumstances of a particular case. But there's nothing wrong with one lawyer handling both, but sometimes it just makes good sense for lots of different reasons to separate the two cases and let one lawyer work on the personal injury claim and another lawyer work on the workers' compensation claim.
Of course, I was mentioning it in that the expertise. For instance, since I don't do workers' comp, I better stay the heck away from it and let somebody like Craig, who does, handle those portions of the claim.
Thank you. One of the things that we talked about initially was the minimum liability insurance limits, and we talked about $25,000 per person in liability coverage, and that's not the extent of no fault. The basic no fault that virtually although you can't buy a liability insurance policy in Kentucky without it, requires $10,000 worth of no-fault coverage. They do allow certain deductibles. But I know when I was a much younger lawyer and the legislature adopted no-fault for Kentucky, I was against it. But I know now I buy extra no-fault, and perhaps one of y'all can explain whether or not that's a good idea for the people who are watching us to consider.
Well,
Go ahead. I was going to tell a little story, but you probably would be more
I'll let you
interested.
tell your story
All
in
right.
just a second, but I agree.
I knew this was gonna happen.
I agree wholeheartedly with Craig. I buy extra no fault myself, and state law allows you to do that. The insurance companies will sell it to you in $10,000 increments. It's relatively cheap, and it doesn't take much to if you're hurt to any real extent, it doesn't take much of an injury to run up $10,000 in medical bills and wage loss. And so I would highly recommend that everybody get out their insurance policy, look at the deck page, talk to your insurance agent about what coverages you have, and I would certainly recommend purchasing additional personal injury protection coverage.
If you'll remember a minute ago, I mentioned that no fault would cover pedestrians hit by a vehicle and also passengers. And for instance, I'll give you this little story about my mom. And when she was in her, I believe it was late 70s, early 80s, she was really still into playing bridge. And she would get out and go to play bridge, and she would take a bunch of her older lady friends with her. One day, a woman in front stopped, and my mom didn't see her stop and crawled up on the back of her vehicle. In other words, they collided, and fortunately, no one was hurt. But at that point, I said, "Mom, here's what we need to do. You know, since the no fault will cover the ladies insofar as at least their medical expense, and most of them weren't going to have any income loss because they weren't working. But I said, I think we have a duty, or you have a duty, to protect them more than what they are being protected, because my mom's policy limit was $10,000, which meant that everybody in the vehicle that got hurt was going to get a maximum of $10,000 in medical expense payments from my mom's policy. So for very little extra premium, and the insurance agents don't always tell you about this additional no fault that you can buy, but for very little, I think we bought up to about $30,000 or maybe somewhere in that area of coverage. And so if my mom had an accident subsequently, then each of the ladies would have had their medical expense covered by no fault up to the maximum limit of, say, $30,000 instead of the mere 10. And so really, you're not only protecting yourself, but you're doing what I think you have a duty to do, and that is protect those that you love and are friends with that are riding with you.
Of course, that kind of depends on what the specific provisions in your policy have, because some of the insurance carriers, with respect to the added reparations benefits, draw a distinction between the people that live in your household and anyone else. So if bridge playing friends were involved in the same accident, they may or may not be entitled to the added benefits that you had purchased. It just depends on what the specifics in that policy provided. One of the other things that I think is important while we're talking about no-fault coverage is, because medical expenses are so high that very, very, very few people can afford to absorb that sort of loss from their own pocket, many times there are overlapping fields of coverage, and we've talked about the possibility of workers' compensation and no fault. Another thing that many folks have is health insurance. And I sometimes get asked the question, should I turn these bills in to my motor vehicle no fault coverage, or should I let Anthem or Bluegrass or one of the other health insurance carriers cover it? And there are a number of factors that go into that. In other words, do you have some sort of income replacement? Because you have a right as the insured to write your no-fault carrier and say you want the no-fault applied to your wage loss benefits in preference to paying it out in medical bills, because the hospitals have learned that the no fault pays them better than the health insurance carriers. And so if they can send the no fault carrier a bill for your first 3 days in the hospital, you can wipe out that $10,000 straight away if you don't get to somebody that can analyze the pros and cons of which way you're better off, so that you can interact with your own insurance carrier in a manner that maximizes what you get back from the insurance coverage you've paid for.
That's a good question for the judge, because that's where we get our law on that. I hope I didn't put you on the spot.
I'm not sure I understand the question, to be honest with you.
What is that case, bluegrass? Well, it's like when somebody comes into your office and, and say they've got a $10,000 maximum no fault. And do you want to turn that over to the no fault carrier, their carrier, and have that medical bill paid? If you do, you wipe out all the no fault. There's nothing left to pay them for their income loss.
Discussion was.
Yeah.
I'm going to defer to the practitioners. I really think that's more of a practitioner question.
Let me do this, but you'll probably help me with the case. Is it bluegrass something or other? There's an appellate case out there, and basically what it says and what you can do is you can say to the no fault carrier, I don't want you to pay the medical expense right now. What I want you to do is to hold on to that $10,000 and pay my client for his or her wage loss as it becomes due. And your client might be off 6 months and might need that income from no fault. And then you turn to the health carrier, such as Anthem, Blue Cross Blue Shield, whatever, and you have them or that company pay the medical expense. So you've got income coming into your client, you've got the medical expense, at least to some extent, being paid. There'll be some deductible copays and so forth. And then when you get to the end of the case, if you recover for the client, either by settlement or judgment after jury trial, you can go ahead and negotiate with the health insurance carrier to pay them back either 100 cents on the dollar or maybe 70 cents on the dollar, whatever, of the medical expense that that company has paid out. And what that does is it helps your client a whole lot to get through all of the trauma of having to be off work and be working on trying to let the injuries resolve and heal, and they don't have to worry about these money matters as much as they would otherwise. I think that's where we're going with this.
Yeah, and Len, a couple of things that we might want to point out to folks is that the reservation of your PIP benefits can be made by state statute. PIP will pay the medical
Tell
bills.
us what PIP stands for.
Personal injury protection, also what we call no fault, but when we're talking with most insurance companies, people call it PIP for personal injury protection. The medical bills they'll pay 100% as long as the bill is reasonable in amount and treatment's reasonably related to injuries received in the wreck. A lot of times, though, people are surprised to learn that in terms of the wage loss, it's only 85% of the average weekly wage, but not to exceed $200 per week. And that's if you have a basic PIP or no-fault coverage. Mm-hmm. One of the other benefits of buying the additional no-fault coverage is that as you buy more and more, your wage loss benefits can increase. For example, if you buy an additional $10,000 in no-fault coverage, your wage loss benefit can actually increase up to $250 per week. And you guys make a great point. That's something that really needs to be analyzed quickly. Mm-hmm. Because if it's not analyzed quickly and the direction given to the insurance company, oftentimes they'll write one check for a large bill, and then the no-fault benefits are wiped out and the client has no way to recover anything for wage loss. $200 per week may not be a lot, but when you're in dire straits, it's better than nothing. So I think it's important for people to make that analysis quickly.
As a lawyer, whatever stress and strain you can take off of your client while the case is pending, you need to go ahead and try to do, and that accomplishes it. I'm glad you mentioned it's not a whole lot, but the extra $50 and also the limitations
it can go higher than the additional $50.
Right.
It just depends on how much additional you purchase. But one of the things that I would like to point out is that while we've talked about, yeah, turn it over to the health insurance carrier, if you've got health insurance so you can preserve the wage loss coverage, that's not always true. I mean, that's not always the best way to go. It just depends on your particular fact pattern.
Correct.
If for instance, you were hurt while on the job in a motor vehicle accident and you had health insurance, the last thing you want to do is turn the medical bills in to your health insurance, simply because, as Len talked about, when the case is ready to be settled, in other words, when we start talking about getting something other than just medical bills and basic wage loss paid back, these different sources of medical bill payments all have different rights to recovery. And I know when I started practicing law, it was just real simple. You know, who was at fault? What were the injuries worth? You settled with the insurance company and it was over with. Well, these days, once you agree on those factors and get a sum set up, then you go to phase 2, which is arguing with the workers' compensation carrier about whether or not they're entitled to any of their money back, arguing with the health insurance carrier about whether or not they're entitled to any money back, arguing with the no-fault carrier over whether they're entitled to any money back. And the problems are that there are different rules applicable to each source of payment. And I guess I'm getting into more detail than I should, but the bottom line is this is something that there is no one-size-fits-all advice that applies. And so it is a good idea if somebody's been seriously hurt in any sort of accident, and particularly motor vehicle accidents, that they get some guidance early on in terms of what's going to be in their long-term best interest, so far as just making maximum use of the assets that are available to them.
Let me
along
make,
those lines-
if I could, Judge, let me just make one quick comment as a piece of advice. It sounds like, gentlemen, from where we're coming from here, that one of the best things that a person can do is, if they have a good insurance agent and they trust their insurance agent, a friend, whoever, go to that agent and give the agent what you need as far as, you know, what's going on with you, and then get advice from the agent as to what you should really have in the way of insurance coverages. And if you're not in that situation and you've got a lawyer friend, go to your lawyer friend that knows something about it. And then that way, before the accident occurs, you'll be in good shape from an insurance coverage standpoint. Judge?
Okay. Kevin, tell us about the additional coverage that's available from an underinsured and an uninsured standpoint.
Well, under Kentucky law, if you purchase liability insurance coverage, which you're obligated to, the insurance company is also obligated to sell you what's called uninsured coverage. And you're going to get it unless you specifically reject it in writing. I would never recommend that anybody reject uninsured coverage because unfortunately, all too often there are cars driving around on the roads that are not insured. And so just as a good example of how bad things could be, if you have a wreck and the wreck is caused by someone else and that the vehicle that person's driving is uninsured and you don't have uninsured coverage, you're going to be limited to whatever no-fault coverage that you may have available to you in most instances. I mean, as we've talked, there's no one-size-fits-all, but that you want to have uninsured coverage so that in the event you're injured by an uninsured motorist, you've got a way to make some recovery for yourself. Underinsured motorist coverage is not mandatory. It is available for people to purchase at their option, and it is to cover you in the event that the injuries and damages that you sustain as the result of a wreck are severe and the person that caused the wreck and caused you to be injured doesn't have enough liability coverage to fully compensate you. So in that event, that person will have been underinsured. You can hopefully collect from that person's liability insurance company, and then you turn around and have a claim against your own policy for the underinsured motorist benefits.
Let me give a quick example. Let's say a client walks into my office and has been in a 3-car motor vehicle accident. My client and 2 other vehicles. All right, vehicle A, one of the other vehicles, is uninsured. There's no coverage there. All right, if my client has uninsured, or what we call coverage, then we can look to that coverage and get my client some money there for their damages, or his or her damages. If the client didn't have uninsured motorist coverage, then there would be no money that the client could get except for the no fault. Now, as to this second other vehicle, vehicle B, let's say that that vehicle has the minimum coverage mandated or required by Kentucky law, which is $2550. That's $25,000 for one person injured, or $50,000 for a multiple. So if you've got 5 people in the car and they're all injured, they got to split that 50 up proportionally according to their damages. So if my client didn't have UIM, or underinsured motorist coverage, then wouldn't be able to recover any more than the $25,000 that's available under Car B's policy on liability. However, let's say that my client's damages are $50,000 and my client has UIM, or underinsured motorist coverage, of $25,000 maximum policy limit, and the other vehicle has the $2550 policy. Then my client can recover the $25 from the other person plus the $25 from their own carrier, and now they've got $50 and their damages are paid in full instead of only getting half.
Well, let me toss this one out as far as what any of you would tell a potential client when they come in and the person that caused the accident, they've been contacted by their insurance company and say they just have the minimum $25,000 coverage, and they've offered the policy limits of $25,000. And they also have their no fault, and their company has told them that they're going to pay their $10,000 on the no fault, and that they're not going to have to take any of the $25,000 to reimburse it, that they're going to be able to retain that also. They come to you. What type of advice would you give them as far as, should they hire a lawyer in that situation, and what type of fees are normally charged? What type of cost would they look at? And what if you're not able to attain for them any additional funds? Craig?
Well, I can't speak for every lawyer in the area, but I know most folks who have ads in the Yellow Pages, and that seems to be, I know that's the thickest block of names in the Yellow Pages, but most of the folks who handle personal injury claims offer an initial consultation free of charge. I know I have for 33 years. If folks come in and the insurance company's already offering them what I call all the water in the well, then there's no charge for that, because if it's that obvious. But one of the things you got to be careful of, and that's why people should not be reluctant to contact somebody that knows the rules, to get in touch with a lawyer on something like this, is if they have been offered policy limits by the person who, the policy limits on from the insurance company covering the person who caused the accident. If they have underinsured motorist coverage, and people who have been around the system as much as the 3 of us do, anybody that's familiar with the way insurance works will have underinsured motorist coverage. If you're going to load up on something that protects you and the people you love, not other folks. So if you've got underinsured motorist coverage, there are very specific rules you have to go by, a very specific procedure you have to go by in order not to mess up your own underinsured motorist coverage if you get offered the policy limits by the insurance company for the person who caused the wreck. One of the things that I get asked more often than that is, somebody's been in an accident and the other person's insurance claims person wants to take a tape-recorded statement from them, or wants them to fill out a detailed form about the facts. And I know when you get into that initial conference situation, a lawyer's advice is worth quite a bit, because basically they're not doing that, quote, just to get the facts. They're doing that to build a case against you, because they won't share with you the statement that they took from their insured. They won't share with you the statement that they took from anybody else. So if you're going to cooperate with them, so everybody's looking at all of the facts, then make that proposition with them. Yes, we will cooperate and tell our story if you will share with us the other side. And that usually puts an end to their request for the tape-recorded interview.
That's the old, what is good for the goose is good for the gander.
Exactly.
Before we move on to another
Oh,
area,
let's go to dog bites sometime.
I do want to talk about homeowners and some of the different injuries, but anything else on automobile, or we think we covered it pretty well? If not, let's go over to
Get a lawyer.
to dog bites and slip and falls and other type of injuries on the home premises. What type of coverage should a person need, should they have, and what type of rights do they generally have if they're the ones that are getting injured? Kevin?
If you own a home, you need homeowners coverage. If you rent, you need renters coverage. And homeowners coverage is generally going to protect you as the homeowner, and I'm talking in terms of liability situations, not casualty where your house burned or something like that, but just in terms of liability situations, your homeowner's policy is going to protect you from a whole host of potential liability situations. If somebody comes on your property and slips and falls, for example, whether it's out in the yard or inside the house, or as we were preparing for the show, we talked about some other maybe unusual situations that some people wouldn't think of. For example, I think Craig told the story about a client he had that was fishing, and the fella he's fishing with accidentally hooked him in the eye. Yeah. Homeowners coverage is going to cover that situation. Some hunting type accidents, just a whole host of issues.
What about four-wheelers and other recreational type of activity?
Four-wheelers are generally not covered on homeowners policy, except to the extent that an accident occurs on the premises of the person that's insured. So as soon as that four-wheeler leaves the homeowner's premises, it's generally not going to be covered. But I'll tell you, four-wheelers are, that's an area of law that's changing quite a bit. It's changing pretty rapidly because many people get hurt on four-wheelers. They're real popular nowadays. People use them for recreation. People use them for work. People use them just for fun. And I think even in the legislature this past session, there was talk about whether you have to wear a helmet now on a four-wheeler. So my best advice for people that have four-wheelers and use four-wheelers routinely, once again, is go talk to your insurance agent. Tell them how you use your four-wheeler, where you use your four-wheeler, and then make sure that you've got some coverage for the instances where you're primarily using it. You ask another question, I think, about other property situations. One that I have seen frequently relates to use of public property for recreational purposes. There's a statute in Kentucky called the Recreational Use Statute. It would apply equally to public property and private property, but my experience is it comes up most often in public property. And basically it says that if a landowner holds property open for the use of the public for recreational purposes, and they don't charge a fee for the person to use the property, then they have some immunity in the event the person is injured while using the property. I see it come up frequently with respect to public parks. I have also seen cases reported where it relates to private property that might have some unique geography, such as a cave or something that people go out to see and use for recreation. So I think people need to be aware of that. I don't know what they can do about it other than just be, extremely careful. As you would expect them to be.
I have a good example of that, a case I'm working on right now. and a person was injured as a result of a picnic table bench seat collapsing, and ended up being a knee injury, and had to have surgery that evening after the injury. This occurred at a local park in the vicinity of McCracken County. And one of the problems that we had to look at initially was, did they pay anything to get into the area where this occurred? And that's what Kevin was talking about. Fortunately, the answer was yes, because it occurred within a swimming pool area, and they paid an admission charge to get into the swimming pool. If they had been in the other part of the park, where there was no admission charge paid or required, and the same thing had happened, the bench had come loose and they injured their knee, then that person would have not had any lawsuit that could be maintained against the owner of the park. You know, to me, it doesn't seem right. I don't like the policy behind it because, you know, it encourages, if you pay a little money, $1 to get in or whatever, a park maintenance crew to be very careful about that area of the park. But in the other areas, there's no liability, so, you know, the city or county or whoever owns the park is not encouraged to be as safe.
I'm afraid you'll have to run for the legislature to do something about that, though, Len.
Well, of course, you know,
Staying out of politics.
with more and more litigation, I'm assuming that there was a policy behind it to encourage people to allow others to use their property.
True.
You know, back when I was young, some 52 years ago now, it was very common for neighbors to let kids make a ball field out of their extra pasture land, or you know, ride horses on their property and things of that nature when there was no charge involved. But you know, it got harder and harder for some of these small communities to have their festivals because they needed to use someone's farmland for that, and people were concerned about the liability. So I guess that's the other side of the public policy question, especially concerning the individual landowner as opposed to, say, a city. Craig, on the
That's a very good point, Judge.
Thank you. On the home use, we were talking a little bit about some of the trampolines, things of that nature. What should homeowners look for in their policies on exclusions?
If you have a trampoline, just like if you have a four-wheeler that, you know, your kids use, it's sort of like a magnet for other people's children to come play with your children. And because it's also like swimming pools are included in this as well. And because these are instrumentalities that are a lot of fun, but if they are misused or used real carelessly, can result in very damaging injuries and very serious injuries or death, many times insurance carriers exclude coverage for those particular items. So if you've got a swimming pool or thinking about getting one, or if you've got a trampoline for your kids, even if it's a small one, it is worth the time and trouble to call your agent, or better yet, get out your own policy and read the thing and see what it says.
Good luck.
Because if they, that's true. But if they, you know, if they've got an exclusion, you're bound by what's in those pages that it's so painful to read. But after the accident, it's too late to find out.
Let me ask you a question. Now, you're talking about where somebody is invited over,
Right.
all right, to go swimming. All right, let's say the person has a swimming pool and it's got a fence around it and gates, but they don't lock the gate, and somehow a little kid next door negotiates his or her way over to the pool and through this unlocked gate and drowns.
I believe there's a fairly recent decision on this, and if you've got an enclosed yard, I know there's a case similar to that dealing with a dog, where while generally speaking people are liable for the damage that their pets cause, if they're running loose, if the animal's restrained and what you have is somebody that's basically coming in as a trespasser, even though it's a child, the duties that the landowner has to that child whose presence is not anticipated, whose presence is not invited, whose presence is not going to result in any economic benefit to the homeowner, I expect that you would have a difficult time imposing liability on the homeowner or their homeowner's coverage.
So that probably wouldn't come under the old attractive nuisance type of common law?
It might, Lynn, but quite honestly, I don't know the fine points of that without looking it up, and that's why we keep the computer on the desk.
Judge, the reason I asked Craig that is because when I need to know something about new Kentucky case law, I'll run down and ask him, what have you read recently? So.
Well, I think dogs were just mentioned, and and we've had, unfortunately, some examples of some maulings in our area here in Western Kentucky, and I know that at least one community has enacted an ordinance fairly recently concerning dogs. Could you discuss a little bit for us, again, the owner's responsibilities and the person that might get injured's rights in those situations?
Well, basically, the owner of the if we're talking about dogs, the owner is essentially liable for the damage that the dog causes if it attacks another person. The only safety net that the homeowner has in that circumstance is if he has the animal properly restrained on his own property. But I know, there was one tragic case in one of the surrounding counties where an animal was chained in the backyard, but because there was an allegation that it was a vicious dog and it severely injured a child, the owner was held actually criminally responsible for that. So while I know, pit bulls and Rottweilers are real popular, keeping a dog that has vicious properties or is reputed to have vicious properties puts you into a separate category from having a Cocker Spaniel or a Beagle. And one of the things that you've got to beware of is, there are certain insurance companies that are now writing exclusions into their homeowners policies dealing with certain breeds of dogs. If you want a Rottweiler or a pit bull, you're either going to have to get your insurance from some other company or you're going to have to pay extra for some sort of special rider. So once again, it's just a situation where it is tough to have one-size-fits-all advice. It's just if you've got a dog, you've got an obligation to keep the dog restrained, and if you've got a dog that either by its breed or by its past history you have reason to suspect may be a hazard, that requires extra care by the owner to make sure that the dog does not damage another person.
Okay. If there's anything else on homeowners, please feel free to jump in right now. If not, why don't we move on to premises liability? I guess the most common type of claim we see on that would be a slip and fall type injury. Of course, there are others along those lines, but let's go beyond the homeowner. And when someone is on say a business premises as an invitee and they have some type of an injury, what would be their rights? And again, what's the responsibility of the business owner? Len?
Well, thanks to a recent referral by a good law firm in town, I'm handling one right now. I've handled some of those cases before, and this is a business one, and this is one where there was a slip and fall as a result of a wet floor. And basically what we're talking about these negligence cases is that there are certain duties that people have, and sometimes the duties will be higher and sometimes they'll be a little bit lower. For instance, common carriers have to exercise the utmost or highest most duty of care, and in most instances the general public is just going to be held to what's called ordinary care, what a reasonable and ordinary prudent person would do under the like or similar circumstances. So I think it's important to know that. But back to the question, in this instance, a fellow goes into like a truck stop store, and he goes along the aisle looking for whatever he's looking for, and he rounds a corner and he slips and he falls and injures himself. There was a sign up, and a fellow was there washing the floor. The problem is that the sign was not put in a place that was easily visible to my client for him to be able to be warned that there was a slick floor and that he should either go the other way or exercise caution on his own beyond what he would normally exercise in walking up and down the aisles of a store. And I think it's going to be a good case. because the store owner has that duty to exercise reasonable and ordinary care under those circumstances. And I might even argue that they have a higher duty of care when they're washing the floor because they're creating a dangerous and hazardous situation, which of course we want them to wash the floor. We want clean places, but they are creating a hazardous and dangerous situation. And so, you know, they need to do certain things to warn the public so the public doesn't fall and injure itself. And
Now that, Len, was of course, a situation where, like you said, they were washing the floor.
yeah, you can have other things, defects.
There's recent case law that I'd like for one of you to discuss concerning, say, some type of a spill off of a counter where a jar breaks, or perhaps something seeps out from under a cooler or something like that. What's the obligation of the premises owner in discovering that and warning of that?
See, Craig is going like this, which means he knows the name of the case.
My wife's a school teacher.
Go to push the buzzer and enter.
He knows the name of the appellate case. that
Number
you're talking
3,
about.
I think it's Frazier
There
versus
you go.
Walmart.
Is he right?
Yeah, he's right.
Okay.
There's traditionally what the injured customer had to prove was that the water that had seeped out under the cooler or the spill from the broken jar on the counter had been there long enough that the store owner had plenty of time to locate it and to fix it, because the store owner, because he's inviting you onto his premises so he can hopefully make a profit, owes to the customer a significantly higher duty than what I would owe if I were inviting one of my panel members over to my house for dinner. It's the difference between a social guest and a business invitee. The major change that's happened in Kentucky law within the recent past was, instead of the burden being put on the customer to prove how long the hazard had been there, and if he couldn't prove it had been there for a long time, long enough that the store owner should have found it and fixed it, then he lost, or she lost. What's changed now is they've switched that burden of proving it, the burden of going forward with proof, so that now it's up to the store owner to prove that, you know, they had just been through there. They just conducted a sweep 5 minutes before because they had a log and it wasn't there then. So they did not have enough time to find the hazard and correct it. And so as a practical matter, it just puts a little more responsibility on the commercial establishment to really be careful about the premises that they're asking people to come on to in order for them to hopefully make a profit. And it's not an entirely one-sided thing. Kentucky, for I think the last 15 years or so, has followed the doctrine of comparative fault. And I have handled a lot of cases where people fell down on someone else's property, sometimes in the context of social guests, sometimes in the context of business invitee. But all the time, the individual who has slipped and fallen is responsible to exercise ordinary care for his or her own safety. You know, you can't just blindly walk through the store, never looking down, and expect the store to be an insurer of your safety. So what the jury is allowed to do in these circumstances is to say, well, if there was a puddle on the floor and it was something about the nature of it gave rise to the inference it had been there quite some time, they can say that the store owner was responsible. But if it was in a really well-lit area and it was purple liquid on a white floor, they could say it was 80% the customer's fault for not seeing it because it was so obvious, and 20% the store owner's fault for not fixing it. Or they could make it 50-50, or they could make it 90-10. You know, if it was at the very end of the aisle and the customer was just making a turn or something like that. You never know what goes into the jury's collective wisdom and how they split it out. But basically, both the store owner has duties that the judge will tell the jury about, and the customer has duties that the judge will tell the jury about. And I think it's a wise thing that in Kentucky we let that committee of people drawn from the community make the judgment call about, who who was at fault in causing the person's injuries, and to what extent did it contribute?
Could I ask this? Was that, because I just can't remember, was that Frazier case decided by the Court of Appeals and discretionary review denied, or was it decided by the Supreme Court?
Supreme Court had the final say on it, so I guess they
thought
granted.
so.
That's right.
Is that right?
Right, because it was definitely a change from 100 years of pre-existing law.
Right.
And it's only fair because these stores, in every case I have, and quite a few with Walmart, they'll send people around in a circle, and they want them to go around every so many minutes so that they could say that there was nothing that had been on the floor very long. And it's the same testimony every time, and they're just trying to protect the store. I don't think the stores are sometimes that interested, and I'm going out on a limb here, but that interested in the safety. They're interested in protecting themselves from the liability. So somebody is blindly walking around every 3 or 4 minutes, and you get that same testimony as a defense in these cases. So I like this new law.
We only have a few minutes remaining, and there's still a lot we could talk about. 3 items in particular that come to mind are products liability, liability for our children's negligence, and liability if alcohol is served on a homeowner's premises. Let's go in reverse order and talk about those kind of briefly if we could. What's the responsibility of someone, not just on their own premises, but say they're having a party at some rented premises, but they're the party that's responsible for providing the alcoholic beverage. What's their responsibility and liability? Len?
Well, I spoke just a minute ago, but we're sort of talking about the old dram shop laws. And, you know, they have a responsibility not to serve someone alcohol that is underage, and probably also that might be in some manner or other physically or mentally incompetent. I'm stretching a little bit there. And they also have the responsibility not to serve someone to the point where they get intoxicated. Or don't even say the word intoxicated, that they become under the influence, because that's the law in Kentucky, that you cannot drive a motor vehicle under the influence of alcohol. And if you do it, you know, especially in a business situation, then you're probably going to be liable if they have an accident and injure somebody. You're just taking a great risk in this day and age to allow parties where there are going to be underage children and alcohol present together, and you're taking a huge risk sometimes even in having a party where you serve alcohol. But now, you know, we all have wedding receptions, and, you know, people are going to sometimes drink a little too much because they're having fun.
Well, it's
and
one
you
way.
just have to look at the individual fact situation, but a business has to be really careful, and somebody dealing with underage kids has to be even more careful.
Well, if an individual was having a wedding reception off their premises, but they provided the alcoholic beverage and they were careful to only serve to 21 and over, could they give themselves more protection if they made cab rides available, or they had some type of policy that if someone did have too much where they shouldn't drive, that there was some type of a plan to meet that need?
Absolutely. And, you know, they have the, the Hot August Blues Festival, music festival up at the lake. And I went one year and took my son when he hadn't gotten his driver's license yet. And I thought it was really neat. When we came out of there, we were stopped just for a few minutes, treated very nicely by, I think probably a sheriff or deputy sheriff, I don't remember, and asked if we'd had anything to drink. And the person had a chance to smell the driver's breath. I was the driver. And I thought that was a really good thing for 2 reasons. One, protection of the public, both the driver leaving the Hot August Blues Festival and the people that are going to be on the road when that driver got out of the parking area. And secondly, it protected those that were putting it on to some extent from liability. Because there's a lot of alcohol that gets taken in there, and everybody knows that.
Craig, along the lines of responsibility for children's negligence, what's generally, in just a minute or so, the law on that?
Well, the general rule is that unless the parent is somehow or other directly personally involved, the parent's not liable just because of the parental relationship for their child's negligence. But if there are a number of circumstances where that doesn't apply. I guess the largest one is in the circumstance where you flip the car keys to your 17-year-old son and say, go down to the store and get us some milk, or any other errand. Or just you flip him the car keys and he wants to go to the movie with a girl or whatever. And in those circumstances, there are specific exceptions, like someone who owns the car, who allows a minor to drive it, becomes responsible for that minor's driving. If I let my 12-year-old have a 357 Magnum to impress his friends, that's a classic sort of example of where I personally am negligent in entrusting a really dangerous instrumentality to someone who's obviously too young to have the maturity of judgment to handle it. So that, of course, implicates my own judgment in allowing my child to have something like that. But generally speaking, if my child, is out fishing and hooks another child because he's not paying attention to how his back cast goes, I'm not personally responsible for that. Even though if I've got homeowners coverage, they may take care of my child's liability.
Okay, let's turn to our final issue. And Kevin, I'd like to ask you to, a minute or so, talk about products liability.
Well, very quickly, I think that people need to be aware of products liability claims. Nowadays, we get products in America, we get products from all over the world. Some of those products are very well made, others are not. And if a person is injured by a dangerous or defective product, then they have a potential claim. Kind of a tragic example that I heard recently, a national shoe manufacturer manufactures shoes for kids. They got those shoes from some other place in the world. In the box of shoes, there were these little, I would say, charms that were tied onto the shoestrings. And there was no warning on the charms. A little boy, I believe it was in Chicago, swallowed one of those, and unfortunately, it was 98% pure lead. Lead is toxic. It poisoned the little boy. Before they found out, tragically, he died. There are instances that it can come up at work, it can come up in a car accident, it can come up mowing your yard and products you use around your house. I just think people need to be aware of that. And if they're injured by a product, maybe talk to somebody and see if there was something wrong with the product. Maybe there was, maybe there wasn't.
Okay, thank you, Kevin. And we would encourage our viewers, if you have a claim or a potential claim or a question concerning a claim, to contact one of our panelists, Kevin Shannon, Len Ogden, Craig Housman, or another member of the Kentucky Bar Association. And we thank you for viewing today, and we thank McCracken County Bar Association and the West Kentucky Paralegal Association for sponsoring this program. Thank you.
Judge.